This podcast may contain disturbing content for some listeners. It's intended for mature audiences. Listener discretion is advised. This is True Crime XS.
There's a lot of stuff going on in true crime, and I want to kind of catch up on a couple. We got a note from Michelle. I don't think I'm going to use her last name. She emailed me about an old episode. She basically described doing the same thing I do, where I go back and I listen to certain episodes I liked of different podcasts. She had brought up an old Israel Keys thing, so I did want to mention that there are going to be some Keys episodes coming up. I think so. What happened there is you found a spot, I found a spot in sort of time and geography. We looked at some cases, and when we do the Keys stuff specifically, I go records hunting. We have this one interesting spot we're going to talk about where there's a missing couple that doesn't make the news, really. And we're going to talk about that case. We have another missing couple that's not even close to that area, but they're only missing for a day. Then they're found. And I think we're going to have to talk about them in generalities, because technically their case is all wrapped up. And I don't know that I'll use their names and stuff because of the circumstances there. But they barely make the news as well. We had there's one specific case that I feel like is sort of the catalyst case for Israel Keys as we know him. And I've been in touch with the family, or started to be in touch with the family there. And then I've started trying to get the police records. This is a very old case. It's a 1998 case, 1999 case. It's right when he's going into the military, but I have a specific idea about it. But anyways, they don't want to give up any records related to it. I'm in the appellate process, and unfortunately, because of where it is and how that works, it's not. The person I'm talking to is an elected official, so it's actually a matter of filing a lawsuit, which is unusual in records cases. A lot of times there's a different appeals process, and in this case, it's interesting because this case came up on my radar 2 years ago. I looked at it, I sort of set it aside, and I went, I'm going to bring that up to Meg at some point because they have a new cold case unit in the department that it's in. And they have the case now, and they're not doing a lot with it. But we are going to talk about him. We're going to talk about another serial killer. So I think that stuff is going to be I think we're going to do the other serial killer first, and whether or not that guy's a serial killer. And then we'll segue into some Keys stuff. So last year, you and I did Cruel Summer. And I think this year, we're going to do fall episodes about Keys. And I don't know how many there'll be. Right now, I'm looking at 3 or 4 that I've run by you. That I think it'll be 3 or 4 episodes worth that we'll do. It has to be new information. If it's not new, I'm not coming back to it. But Michelle, thank you for your note about the old Keys case. That one may come up again, the one that she mentions in there. I don't want to tell the audience what it is because it's kind of cool. It's a case that you're pretty staunch and sure, Meg, that it's not a Keys case. And my defense of my position has been that it could potentially be a case where they were witnesses or something. That case is hard for us to discuss because there's not a lot of information out there.
Right. And it's an old case. And yes, I feel very confident that it isn't Keys. And, it's funny because I just listened to this week's show, and you put the outro, or I'm not sure, is that what our coda? I'm not sure how you refer to it, but you actually put it in there about how we were discussing how when we were talking about that death penalty case at the end of the show, I didn't actually realize we were still recording, I don't think, but I was like, why didn't you bring up your opinion?
I wanted to be fair, and I also wanted the audience to have a glimpse into like how obstinate I can be about things. Because okay, so we're putting together essentially what's a true crime talk show in the form of a podcast. So when we do that, even though like we're sitting here and like sometimes I realize it kind of sounds like we're reading or we're reading from notes or we're using sources.
It
We
is
put in
all off the cuff.
we put in a tremendous amount of research in so that you and I can have a conversation
And
where
we
it
don't
sounds like a
talk.
conversation.
And we don't talk outside of the show. Like we don't have a rehearsal. There's not enough time in the day to rehearse. And so everything that comes out is for the most part, it's unplanned, right? I mean, we have information about the cases ahead of time and we do our own research and we sort of go back and forth like over messages. But for the most part, except for the fact we've been working together this long, like we don't absolutely know what the other one's going to say. We can make a good guess, right? I thought that was interesting though, because I felt you say that it shows how obstinate you are. And to me, it shows how like pushy I am.
But I felt like I tend to edit towards the pushy side because it's not like I'm trying to like show you as pushy, but a lot of times the best arguments that you make that I understand are made because I have been sort of a stick in the mud or worse, straddling the fence, like a fence straddler, where you say something and you only say it that one time, but that's the time that I think the audience would most relate to. And the other thing is with our demographics, I think that we are our demographics. Like you are a big piece of our demographics and I'm a big piece of our demographics personality wise. So I keep that stuff in there because I think it relates to two different sides of the coin. And I think that's important. Also, like of the two of us, you're way more logical than I am. I will take a flying leap and you will just look at me and be like, that is endless possibilities. And you're never coming out of that bottomless pit that you're jumping into with your flying leap.
Right. And I feel like I've never been able to be like that because I don't get anywhere.
Yeah. And, you know, we have a lot of stuff that never makes the air in terms of like we've recorded like whole episodes and in at least one instance, like a series of episodes that like I can't end up putting it all together. So I've tried this year to be really cognizant of our time and to make sure that like what we do record when we're recording makes enough sense that like that people can follow along. So this is where we are in time right now. Summer's here. It's July. I wanted to ask you about something. Did you see that Justin Ross Harris's case got overturned? Do you know the case I'm talking about? This is a hot car death of a child down in Georgia.
Yes, I didn't recognize the name, but I know who you're talking about. I did see it get overturned. We haven't talked about that yet.
I don't know if we have. I didn't hear it in the recordings, but I wanted to mention it here, and I can cut it out if we have a future.
Right, and so the reason that it was overturned by the appeals court was because they brought in information during his trial that it lended towards like bad moral behavior, which was that he was having an affair, right?
Yeah.
And so the appellate court, and I can't remember this exactly, I don't have it right in front of me, but basically the appellate court just said that it was improper to use the context of his text messages. I think the implication was that like basically he was, you know, so busy at work, basically sexting with this woman he was having an affair with while his son was in the car dying, basically. And
Correct.
so the appeals court, they said that it, you know, it outweighed the damage it did outweighed the actual evidence it provided, basically.
Yeah.
And so they overturned it and they sent it back for a new trial, right?
Yeah, it was like all the like so the appellate court actually upheld it. This is the Supreme Court, which is also an appellate court. So I mean, you're not wrong. And in a 6-3 opinion last month, the state Supreme Court ruled that Harris did not receive a fair trial because the trial judge allowed days of improper and highly prejudicial testimony about Harris's extramarital sexual activities, such as sleeping with prostitutes and sending graphic texts and photos to minors. Such evidence ensured that the jurors didn't miss the point that he was a repulsive person, said Chief Justice David Namias in writing for the majority. But if Harris is to be found guilty of his son's murder, it needs to be a jury that's not tainted by that sort of evidence. Now, this doesn't let him out of prison because he had additional convictions for attempted sexual exploitation of a minor and texting sexually graphic photos to a minor that he got 12 years for. But this does boot the life without parole decision. And for people who aren't aware of that case, which I don't think is a lot of people, this case is from 8 years ago. Justin Ross Harris left a 22-month-old Cooper Harris in a hot car and basically went to work. It was a big trial down in Georgia. And if you wanted like a fantastic take on it, the Atlanta Journal-Constitution, they have a podcast called Breakdown. And it's either the second or third season, I think, that Justin Ross Harris's case features. That is great coverage of the Justin Ross Harris trial. It's done by a gentleman named Bill Rankin. It's a really good podcast overall to listen to, but it's sort of hit or miss on when they release episodes, and they do like 10 at a time on a specific case. The Justin Ross Harris case is covered there. I saw that I guess she's now his ex-wife, Leanna Taylor. She's in the news, and she sort of agrees with the decision by the Supreme Court that he probably should not be doing life without parole. In fact, she goes as far as to say that the Cobb County authorities involved were overreaching and misusing power, and that's how that verdict came to be in the first place. I thought that was an interesting perspective.
Well, it is. And so the key will be, so they'll plea it out to some sort of sentence, right? Which I don't think they're going to just let it go, like not retry him, right?
No.
Because that would involve them dropping the charges, and it was too big of a case for them to drop the charges. But they'll either, make some sort of plea deal with him, or he will go back to trial, and the trial court will have to follow the guidance that has been given in overturning the initial verdict by the Supreme Court. And so that would involve, that doesn't mean that they can't use any of his text. It's just they can't use the things that were improper, that what the court has said is improper. And, it's a fine line we all walk if we end up being criminally charged with something, as far as what bad acts can come in versus because you're on trial for a crime. And the crime has a specific statute that has been put in place by the state that has elements that have to be met, right?
Correct.
And you really don't, you're never convicting someone on their overall moral character.
Yeah, that's an important point. I think, so what I think they end up doing here, I think this will end up being an Alford plea to probably second-degree murder, and if his attorneys have a pretty clear line there with the prosecutor, is a very expensive trial because of the depth of it and the number of days they put this on. I don't think they're going to retry it, but I bet they try. If I were a defense attorney in that position, I would want to run it as concurrently as humanly possible for a manslaughter or second-degree murder charge with the sentence he's already got to serve. That basically would see him getting out. I think it'll see him getting out around 2030 based on Georgia's sort of good behavior rules. But
what was the initial charge? Was it first degree?
This is felony murder and first-degree murder. He was convicted of both. So he was convicted of, the way Georgia works is they have one of those really archaic felony murder rules where if you commit felony murder, it's just straight up first-degree murder.
I see. What was the felony he was committing?
I think it was child endangerment. The way the trial went down in the notes I have, and I don't know if we've talked about this a lot. I'm not going to spend a ton of time on it, but I did want to mention it. He is convicted of malice murder and other charges. The theory being, because they moved this trial to Glenn County. I remember that. Okay, so he had 8 counts against them. malice murder, felony sexual exploitation of a minor, and the negligence is considered to be on purpose.
And that's the
So
malice element of it.
yeah, so the malice element makes it first degree, and then so this was considered to be child endangerment, which is a felony in Georgia. So that also makes it felony murder. But they convict him of both, and both are overturned. So he was originally sentenced to life imprisonment without parole plus 32 years. His sentence now is down to roughly 12 years. It's either 12 or 14, depending on how you look at it. But at the end of it all, I think what will happen is they will. So those other charges stand. The felony sexual exploitation, that stands. I believe they will try and make a sentence, like basically use some kind of plea deal to enhance his existing sentence that wasn't overturned. And that'll be probably all we hear about it.
That was a really big case, though.
Yeah, it was a big case, and that's why I mentioned the Breakdown podcast and their work on it, because it was a good. At the time I was listening to it all, it was a really good listen, and they were kind of keeping it up to date as the trial went on, which made it like fantastic for me, because that was one place and time I couldn't follow it as closely, and I definitely couldn't live stream it or anything. And they also covered the Ahmaud Arbery trial, which is one of those busted episodes where you and I never were able to really talk about it in a way that it fit into our podcast. So you can listen to those on the Breakdown podcast. And, this is going to be interesting to see how it plays out for Justin Ross Harris, for his family, because they lost. It's weird, like when you're in a situation like that where you lose a small child, and then so you've got him and you've got his ex-wife, and then all the people around them for friends and family are dealing with the fact that not only did they lose a small child, his entire life gets put like on the front page of the news and on the news every night for months on end.
That's something that, you wouldn't wish on anybody, but it happens. I mean,
yeah, you're being tried in the court
tragic.
of public opinion. That was like one piece of true crime news I wanted to mention today before we get to sort of the main case. I wanted to bring up something. I think you saw this. Did you see that Princess Doe has been identified?
No.
So this is not Precious. This is Princess. To clarify those. So Princess Doe is a case I've been following for a very long time. On the morning of July 15th, 1982, a gravedigger named George Keiss discovered a body in the rear of Cedar Ridge Cemetery up in Blairstown, New Jersey. The body was found lying on its back just over a steep bank that leads to a creek below, but the victim's face had been beaten beyond recognition. At the time, they did not know how she had been beaten, and the body had significant decomposition at the time of its discovery. The girl, it was a young girl. They knew this. She was wearing a red short sleeve shirt, and there was a peasant style skirt found lying on top of her legs. There were no undergarments found with her, but they were never able to determine if she had been sexually assaulted or not. However, there was a golden cross necklace that was tangled in the victim's hair, and she had earrings in her left ear. She had red nail polish on her right hand. They couldn't find any scars or distinctive birthmarks or tattoos, and they couldn't figure out how to present that because they weren't sure if it was because of decomposition or because she didn't have them. Her front two teeth were slightly darker than the rest of her teeth. She had her appendix, she had her tonsils. Forensic anthropologists worked on this case for a long time, and they determined things like the victim wasn't pregnant, she hadn't given birth. They believed that she was between the ages of 14 and 18 years old at the time of her death. Toxicology did not reveal any traces of drugs, but it was a test run at a time when they weren't sure how much time had elapsed between the death and the discovery of the body. So they weren't 100% sure that they could get a real tox screen. They did try, but they thought that the body had been there at least 3 days, and it could have been even longer. It was a hot and humid summer up in New Jersey at the time. The medical examiner wrote in the autopsy they believed that the girl had attempted to fight back or defend herself. She had trauma to her hands, she had trauma to her arms, and she had serious trauma to her face. So for many years, Princess Doe was thought to be a girl named Diane Janice Dye. And she was a missing teenager from San Jose, California, who vanished on July 30th, 1979. So this theory was put forth by multiple law enforcement officials at different levels, like city, county, state in New Jersey. They held a press conference and said that Princess Doe is Diane Dye. But this guy named Eric Krantz, he was Princess Doe's original lead investigator. And actually, he's the one, if I recall it correctly, I believe he named her Princess Doe because he wasn't just a lead investigator. He was also the first person to come to the crime scene in her case. Okay, he maintained that Diane Dye was not a viable candidate to be Princess Doe. Diane's family felt the same way. And because the people in California, particularly the investigators, they got really upset that New Jersey law enforcement was declaring Diane to be Princess Doe. In 2003, Princess Doe's DNA was compared with a DNA sample from Diane's mother, Patricia. And at that time, it was determined that Princess Doe was not, in fact, Diane Dye. In 1999, there was some evidence that came to light that a couple named Arthur and Donna Kinlaw might have been involved in Princess Doe's murder. They were arrested in California for attempting to commit welfare fraud by using the name Elena. And Elena was traced to a Long Island native. When the police questioned her, she gave them details about the murder of someone named Linda. And her testimony put the Kinlaws behind bars. Donna Kinlaw gave details about 2 murders that she knew that Arthur Kinlaw had committed of 2 other female victims who to this day still remain unidentified unless I've missed something this year. After Arthur gets faced with a death sentence, Donna tells authorities that he had killed another woman in 1982. She told police that she was with Arthur in the cemetery and witnessed him committing this murder. So there's another report that states that Donna said that in July of 1982, her husband had brought home a teenage girl, left home, and then returned without her. He apparently, in the sort of days right after that, he apparently disposed of his own clothing and he cleaned his car. And then he threatened his wife, claiming that if she changed anything or didn't go to work or whatever, he was going to take her life as he did to this girl that didn't come home or that he brought home but then didn't bring back. So there was a lack of corroboration there. Arthur Kinlaw did not get charged. And then you have to understand, like with all this happening in sort of the span of the 80s into the 90s, because what I just described is happening in the 1990s. So there's a lot of retirees in here, and it's changed hands multiple times. The belief is that Kinlaw did it, even though they could not provide a name for Princess Doe. But the cops doubt the confession, so they let it go for like a long time. There's a guy in the mix named Lieutenant Stephen Spears that worked for the Warren County Prosecutor's Office, who was the holding jurisdiction for Princess Doe. While he questioned the credibility of their statements, he did believe that the victim was from Long Island, New York at the time. Donna Kinlaw gets interviewed by a forensic artist, and she creates a sketch of the girl she claimed to have met. And that does end up matching with the Princess Doe composite. So Arthur Kinlaw is still in jail on 2 counts of second-degree murder. There are multiple other suspects that have been considered to be involved in the Princess Doe case. So people start seeing images of this girl's clothing in a newspaper. And this witness comes forward. Her name is Anne-Marie Latimer. She remembers seeing a girl purchasing cigarettes on July 13th, 1982, wearing the skirt. Like that's what she remembers is the skirt. And she thinks that she remembers the color of the red shirt with that skirt. And there's pictures of it. Did you ever see the pictures of this? Like where she's got the long, my wife wears skirts like that. That's one of the reasons she stood out to me. Like the long princess skirt.
Yeah.
So that's what the witness remembered. Multiple people come forward They traced the shirt and the skirt to a manufacturer in the Midwestern United States, even though it doesn't have brand names. Latimer states that she was shopping with her daughter at a supermarket across from the cemetery, and she was able to like give details on the girl's clothing that she had to have seen it in person to know. The investigators felt like there were multiple people, three of which reported after viewing photos that they had bought similar clothes at a Long Island store that had been closed. It's unknown if the store had other locations, but in 2012, they put this composite out of the victim to generate new tips because they felt like it resembled several different missing girls kind of around the country. In 2020, they re-exhume her body. They take her out of the Princess Doe grave. They use a grant and they do DNA extraction to do genetic genealogy. And they have all these different theories that like run around about her. One was she could have been a runaway. She could have been an individual that had a fake name. They thought that she might have been employed at this hotel in Ocean City, Maryland. They did different types of isotopal analysis where they like were examining her teeth and they were trying to figure out if she was from the Northeast or if she was more from the Midwest. At one point, they even said she might be from Arizona. So while Princess Doe was buried January 22nd, 1983, and then sort of re-exhumed, they finally have identified Princess Doe. And here's how that went down. In May of 2021, NCMEC and investigators were collaborating with a company called Astria Forensics. And they had been talking about obtaining DNA markers from degraded samples of Princess Doe's body. On June 18th, 2021, investigators were told that Astria Forensics had agreed to extract the DNA and construct a profile. On February 10th, 2022, Astria Forensics tells investigators that they were able to create what's known as a DNA data file, and it was successful. Then they take the results and they send them over to these consulting genealogists that work with NCMEC. I'm saying the short version of the National Center for Missing and Exploited Children. In case people don't know what that is, that's NCMEC. They have this company that comes in called the Innovative Forensics Investigations. They do genealogy work. The managing officer at that time was a woman named Jennifer Moore, and she agrees to perform unlimited genealogy free of charge on this case. They announced that they have a candidate for Princess Doe in February of 2022. Investigators then go to West Babylon, New York, and they meet with a man named Robert Olenek Jr., because they have narrowed it down that Robert Olenek Jr. is Princess Doe's brother. So they collect the DNA sample from him, and they collect the DNA sample from Princess Doe. They use mitotyping technology, and they build a mitochondrial DNA profile. Doing this, the Union County Prosecutor's Office has a forensic lab, and they assist, and they create an STR DNA profile through the victim's sister's DNA. The mitotyping technology that the DNA sample that's created there, or the mitochondrial DNA profile that's built, they send the results over to Union County, and then they pull all of this together and they send the whole thing to NamUs, to the University of North Texas Center for Human Identification, which is where NamUs is. On April 29th, 2022, the center there identifies Princess Doe as Dawn Olenek. The formal announcement was July 15th, 2022, which is also the 40th anniversary of when her body was found. Robert Olenek Jr. said that Olenek had left their home at her mother's request. Basically, she was kicked out. She was never seen or heard from again. Now, New Jersey reacted immediately, which is kind of unusual. They charged him with one count of homicide based on witness statements and his previous confession to Olenek's murder. And as a result of like the investigation that's sort of been ongoing. So the theory is that Arthur Kinlaw was going to traffic Dawn Olenek, and she told him to take a hike. He drives her down to New Jersey. He drops her off somewhere. They both end up in this place called Blairstown, New Jersey, which is where her body was found. And when they're meeting back up for some reason, he murders her in the Cedar Ridge Cemetery. Neither Olenek nor Kinlaw had any kind of connection to Blairstown, New Jersey. And for now, Kinlaw is still in jail. Kinlaw is in jail. He's up in Sullivan Correctional Facility in Fallsburg, New York. So they're still kind of running down how to piece together Dawn Olenek's movements. But Princess Doe is 17-year-old Dawn Rita Olenek, Olanick, Olenek. She was born August 5th, 1964, and she disappeared June 24th, 1982, from West Babylon, New York. And it's believed that she died around July 10th, 1982, when she was 17, at the hands of Arthur Kinlaw. That's a fascinating update, don't you think?
It is. I don't know if you realize this, but Princess Doe is the first person ever to be entered into NCIC.
I did. I did realize that she is a huge deal, and she's, her case started so many little things. Is she the first person entered as an unidentified person into NCIC? Yes. Or into NamUs? Okay.
No, the first is the body. Princess Doe is the first unidentified body, recovered body that went in. And so basically what that did was it was a stepping stone towards centralizing access to that type of information.
Yeah. And so NCIC that's the National Crime Information Center. It's basically run by the FBI, essentially.
And so it's been, that gives you an idea of how slow this process is, because, at least it's moving though. But, for the longest time, even now on occasion, depending on what it is, different jurisdictions don't communicate with one another. And NCIC was developed specifically to help alleviate, it doesn't alleviate the need for them to communicate, but it basically gives everybody access to the fact that, Princess Doe's body was found here on this day at this time, and the information. And that way, if it were to trigger something in a different area, they would have access to that information. And so I just thought that was interesting. That's how long, it's been accumulating data.
Yeah, that's wild that she went in there and is now identified too. I love when these older cases get solved. When the mystery is sort of over. I know some things, like when the mystery is over from it, it can be a little disappointing. These are never disappointing to me, that these people found their name and they're back home. And I was so excited to see that news release. It mentions something called the Missing on HBO. I've not seen this documentary. It's called The Missing. It's an HBO. I guess it's on HBO Max at this point, and it appears to be some extensive coverage of the Princess Doe case. Princess Doe is no longer a Doe.
Such a sad story.
It really is, and it's
so young.
Well, I'm just glad that someone in her family knows, sort of what happened to her, because that's I don't know. That's one of those cases. She's 17 years old. She didn't know what was going on, and if she's telling somebody, she's not going to be involved in their nonsense related to trafficking, that just makes it sadder to me.
Yeah, there's just nothing good about that situation.
So I know that's sort of a terrible case for that to have happened to her, and I wanted to talk about a case that is not so terrible. And I don't mean it like that. I just wanted to talk about something that was more. It is true crime for sure, but it's not that kind of true crime. And I've mentioned these guys before. So this is a North Carolina thing that happened in court that shows you how bonkers the system can be. Because, we use these terms all the time when we're talking about attorney generals, we're talking about sheriffs, we're talking about police chiefs, we're talking about detectives, we're talking about district attorneys, defense attorneys, judges, and these people are officers of the court. And I feel like we rely on them in a huge way to keep the court. Like the court system is like the one thing that if it fails, it can really screw up your life. Would you agree?
Yeah, well, yeah, it can screw up. It will screw up your life if it fails. And I think that there could be sort of this, it's not really a pedestal, but like this maybe unearned respect, uh where, and I'm not saying that nobody deserves respect, but I'm just saying like you shouldn't just assume everything's being done correctly just because like it's an officer of the court, right? Like if there's a problem, they can still make mistakes.
Yeah, like they end up in this position where it's sort of above reproach. And I agree with the respect commentary, but I think it's also like there's a legal authority. This is the color of law they're operating under. They're held to a pretty high standard. And so this brings me to a very interesting court document, and some news about it on top of this court document. So what we're talking about here is it's what happened, what happens when prosecutors become defendants. In this particular case, I'm just going to run down the sort of the factual and procedural history to explain it, and then we'll talk about what happens in it. There's a gentleman in North Carolina. His name is Wallace Bradsher. And he was elected to the position of district attorney for the 9A prosecutorial district, which is an area in North Carolina made up of two counties. It's made up of Person County and Caswell County. On the 1st of January 2011, he assumed office. Now, prior to his election, Mr. Bradsher was a criminal defense attorney in private practice, and he employed his wife, Pam Bradsher, at his law office. When he became district attorney, Mr. Bradsher hired Mrs. Bradsher to work as support staff in his district attorney's office. So he's hired his wife to basically be like a legal assistant in his office. In 2013, a gentleman named Craig Blitzer was a criminal defense attorney in private practice considering running for district attorney for 17A's prosecutorial district. Now, these numbers are how North Carolina divides up its jurisdictions. So 17A, or prosecutorial district 17A, is composed of one county, that's Rockingham County. Geographically, it's due west of Person and Caswell counties. So Person's the eastmost county, Caswell's in the middle, and then on the western side of Caswell, you have Rockingham. Just like Mr. Bradsher, Mr. Blitzer's wife, Cindy, worked at his law firm in private practice. Mr. Blitzer was aware that Mrs. Bradsher worked for Mr. Bradsher in the neighboring prosecutorial district. So Mr. Blitzer hired his wife to work on his support staff in his district attorney's office. So you've got these two guys, Bradsher and Blitzer. They're the district attorneys of two neighboring prosecutorial judicial jurisdictions. And they have hired their wives to work for them. So Blitzer asks Mr. Bradsher whether he had any issues employing his wife at the district attorney's office. Specifically asked if it was any type of ethical violation or if it was a conflict of interest in any sort. Mr. Bradsher said he did not. Mr. Blitzer was elected in 2014. Mrs. Blitzer was close to finishing nursing school, but quit school to help Mr. Blitzer with his campaign. Campaigns for these smaller roles that have a huge impact are very time consuming and they're very difficult to mount. They don't get a lot of support from the typical sources that say like a run for Senate or a House representative would get. After taking office, Mr. Blitzer hires his wife to work for him in this district attorney's office. So I kind of said that all out of order because the court wrote it out of order.
They worked in private practice with their wives, both of these men, and then they moved from private practice to being an elected official, which essentially means they're prosecutors for the jurisdiction, like you were explaining, which is the state, essentially, right?
Yes.
And so they bring the case against, all criminal charges. They bring the case in court against the defendant. And so basically, they went from private practice to the DA's office, and they kept their wives in basically the same position. And so
Yes.
I think that's where I don't know. I think it's just confusing and out of order because of that.
That's where we're at. So where this case starts is Mr. Blitzer and Mr. Bradshaw move from private practice. They become prosecutors, the top prosecutor for their district, or the district attorney.
They're
And
elected. by
they're
the way.
elected. Yeah, they're elected. And when they're elected, they hire their wives. The North Carolina Administrative Office of the Courts, which is known as the AOC, they soon noticed that both Mr. Blitzer and Mr. Bradshaw had employed their wives in their respective offices. Margaret Wiggins was the AOC's human resources officer, and she emailed both Mr. Bradshaw and Mr. Blitzer on January 8th of 2015, and she informed them each that hiring their wives violated the anti-nepotism laws of the State Ethics Act, and that they were not permitted to do this. Ms. Wiggins suggested they seek a waiver from the State Ethics Commission if they wanted to continue to employ their own wives. As a result of the information from Mrs. Wiggins, Mr. Bradshaw sought a waiver of the State Ethics Act from the Commission so that he can continue Mrs. Bradshaw's employment. Mr. Bradshaw and Mr. Blitzer were both told they could not employ their own wives while they were awaiting a decision on a waiver request. So while they've presented this information, they're not allowed to have them working there. So Mr. Bradshaw suggested as an interim solution that he and Mr. Blitzer could hire each other's wife as an employee. So both were hoping that the employment change would be temporary. Mr. Bradshaw sought approval from Mrs. Wiggins, who, after consulting with the counsel for the Administrative Office of the Courts, approved the plan because it did not violate the Ethics Act. So now, instead of working with their own wives, they're working with each other's wives. So they all go out for, a couple's date.
And the Administrative Office of the Courts apparently was aware of this and said it was okay.
Yes, they said that their employment was okay.
Actually, they said that it didn't violate the nepotism policy.
Correct. They said that it did not violate the anti-nepotism clause of the State Ethics Act. So they all go out for a couple's date at a local restaurant. At the meeting, Mr. Blitzer told Mr. Bradshaw that Mrs. Blitzer wanted to return to school to complete her nursing degree eventually. Mr. Bradshaw said that he would try to help Mrs. Blitzer finish her nursing degree at a local community college. Mrs. Bradshaw quit her job in District 9A and was immediately hired in District 17A. At the same time, Mrs. Blitzer quit her job in District 17A and was hired in District 9A. As an employee of Mr. Bradshaw, Mrs. Blitzer initially worked in a secondary office located in Caswell County, which was closer to the Blitzer's residence in Rockingham County. Her supervisor was an assistant district attorney named John Stoltz III. He was in charge of that remote office. As her supervisor, he was responsible for approving Mrs. Blitzer's hours in Beacon. And Beacon is a piece of software that they use for timekeeping and payroll at the Administrative Office of the Courts. Because if you're employed in a public office as opposed to like a private attorney, you're considered to be an employee of the courts in North Carolina. Mrs. Blitzer would submit her working hours in Beacon, and Mr. Stoltz would approve it. 5 weeks after beginning work at the District 9A Caswell office, Ms. Blitzer decided that the Office of Reinstatement was unacceptable. She testified she had no space to work, she had no computer, and that the commute was too long. She discussed these issues with Mr. Stoltz and with her husband, Mr. Blitzer. She asked Mr. Blitzer to discuss the issue with Mr. Bradshaw. At trial, she testified her husband said he spoke with Mr. Bradshaw and said that she could work out of the Rockingham County prosecutorial District 17A office while still being employed by District 9A.
So she's going back to her
Old
work
office.
Right.
She testified that she was happy about the change because the new location was air conditioned and cool, and there was a desk and an office for her to work in with a computer, and it was much closer to home. She testified that she was also told she would be permitted to work at home if necessary. This is pre-pandemic, so this is before we were all working out of our basements. Mrs. Blitzer testified that while she worked in the Caswell office, she would go to the courtroom with Mr. Stoltz and speak to victim witnesses, basically anything Mr. Stoltz needed her to do. As part of her job responsibilities, both before and after the change, Mrs. Blitzer was asked to work on cases that District 17A had transferred to 9A because of conflicts of interest that prevented Mr. Blitzer from working on them. One of her responsibilities was a conflict case involving an infant's homicide called the Shockley case. Mr. Stoltz was the attorney assigned to the Shockley case. Mrs. Blitzer testified that she organized the extensive evidence for the Shockley case. In the summer of 2015, the State Ethics Commission informed Mr. Bradsher that the state ethics anti-nepotism laws under the State Ethics Act were not, in fact, waivable. Mrs. Bradsher soon resigned from Mr. Blitzer's office, and she took a new job at a local community college. When Mrs. Bradsher resigned, Mr. Blitzer hired Tyler Henderson. Although he's employed by District 17A, Mr. Blitzer assigned Mr. Henderson to work in District 9A exclusively on 9A matters. Mr. Blitzer did not supervise Mr. Henderson's work. Mrs. Blitzer was still employed by District 9A, but working in District 17A. Do you follow all this so far?
Yeah, that's sort of where it starts going bad.
Yeah, this is where it goes real bad. So sometime in 2015, an assistant district attorney in Mr. Blitzer's office, he tells the SBI, or the State Bureau of Investigation in North Carolina, that Mrs. Blitzer is not working the hours that she says she is. And the SBI begins investigating. And I just want to point out that that's crazy. That you jump from something's wrong here. You don't talk to your boss about it. You don't get advice. Because I promise you, if you talk to your boss about it, I can't find a lot of ways you come up with, I got to tell the SBI about this.
Well, but his boss was the person he was complaining about's husband.
I know.
So I can see where he jumped. I mean, I see what I understand. I don't necessarily think that's the best way to handle it, but I feel like I feel like if he had gone to his boss, he was probably concerned for his own job security.
Yeah, I totally think that would have made it worse.
So he was he was trying to look out for himself as well.
Yeah, so where we end up with, okay, so the SBI opens this investigation, and in December of 2015, Blitzer finds out they're investigating him, but he decides not to tell his wife or Mr. Bradsher. Now, the 2015 investigation that's open just gets dropped. According to the court and the SBI, no one can tell us why it gets dropped. It just gets dropped. So John Stoltz asked Mr. Bradsher to reassign the Shockley case in August of 2015. So this is before the investigation comes and goes. Bradsher took over the case himself, and in early March 2016, Mr. Bradsher and Mr. Henderson, who was hired in the middle of all this, they go over to the District 17A office where Mrs. Blitzer works. They get the Shockley case file from her in order to prepare this case for trial. Now, Mr. Blitzer says that he told Mr. Bradsher about the 2015 SBI investigation that day. So it's March of 2016, and he basically says, in December, I found out the SBI had been investigating us. According to Blitzer, Bradsher told him at this time to please begin to vary Mrs. Blitzer's time with vacation and sick time. And while there may have been some stuff going wrong up until this point, as far as who's employed where and what's going on, as far as like, are they really working, which I think is the point of that first investigation. This is where you go completely wrong. When you basically are a district attorney talking to another district attorney, and you're essentially asking him, and correct me if I'm wrong here, Meg, but he's asking him, will you falsify this document?
That's what it sounds like to me. I mean, I think that work hours are work hours. So the variance would occur naturally if that were indeed the case.
Yeah, I think that's the indication here as far as the court record goes. So the time records that are produced by the AOC and introduced into the trial record for this, they indicate that the only varied hours entered by Mrs. Blitzer occurred between the 21st of January and the 17th of February 2016. It's so weird to me that they basically, both of these guys, looking back, they try to say that Blitzer talking to Bradsher there about entering vacation and sick time is him trying to make sure that everything's on the up and up. So Blitzer testifies that his wife worked these hours that are entered into Beacon until this Shockley case is the file is taken away in March of 2016. But after that, he says that his wife had nothing to do. Although his wife says that she tried to call Mr. Bradsher about having nothing to do, she did not recall whether she had ever left him a message, and she did not recall ever sending him any text messages. She then testified that she thought she probably did leave him a message, but did not remember what she said. And afterwards, she solely relied on her husband to talk with Mr. Bradsher. Also, I just want to ask, do you have your husband make your important phone calls?
No, I actually, it's it's a little bit personal, but I will share anyway. I worked with my husband for a small amount of time. Like, we worked for a company together, and we were married. We had been married for a long time, and the boss constantly went through my husband, like, to communicate with me, and it drove me crazy. And I mean, it didn't work out, but I told, I asked, not that my husband wouldn't give me the information. I just felt like it was one of those very subtle, like, chauvinism type things that happen in the workplace that you don't even realize are happening,
I totally forgot that happened. I remember you telling me this now.
And I thought, because he just wouldn't communicate with me. And so he would tell my husband everything that he needed me to know. And it drove me crazy. So, but anyway, no, I would not have my husband make my important phone calls. And the information that's given in this case about how she, like, thinks that she called her boss to see, I mean, if she's putting in work hours, right?
Yeah.
She's got to know she's not doing any work.
I mean, I've worked in, I would never, my wife and I trade off on certain types of information, I guess. Like, she does certain things where we'll trade off on, like, I think like food orders is probably the one thing that pops in my head. Like if somebody's calling in like some kind of takeout food or something. And I definitely do some telephone and email errands and monitoring of things like related to like our side hustles or whatever you want to call it. But I would never, like, she would never be calling my boss. I would never be calling her boss. And we were in these positions where she has a job where you have to enter something into almost Beacon. It's not Beacon, but it's close. And she has to account for, she's like a public person, public official. She has to account for all of her stuff. You know what I mean? So when you bring up stuff like this, I can see how it would be chauvinistic, but I just find it weird. Like, I just find it so strange that, like, that's the conversation that would be had. And I tried to think, like, is it because they're friends or something?
I think the only reason that that's said, and now this is what we're reading from is like record of the case, right?
Yeah.
And the only reason this is even coming up is because like it had to be accounted for somehow, and that's like the best way they could put it.
Yeah, I think the main thing that what we'll find is they didn't have any other way to explain what they'd done.
Right. And so essentially what was happening there was she wasn't working, but she was entering hours. So now, and that's how they explained it.
Yeah. So, she states that like she lets she lets the men talk. I guess that's the way you would say it.
It's so bizarre to me.
And Mrs. Blitzer says she had always planned to return to school to complete her nursing degree, and she learned that she was not going to be able to complete her nursing degree through the Person Community College because after she had completed the required testing, they wanted her to retake most of the curriculum. It was like at least half of the curriculum or almost half of the curriculum that she had already completed before she withdrew from her previous program. She didn't want to do that. She didn't want to take those classes again. So she began to explore other ways to finish her degree, and she chose to apply to an accelerated nursing program, which required her to retake a few courses. So Mrs. Blitzer begins online courses while she's still employed by District 9A, working in District 17A. Mr. Blitzer does what all good husbands who employ their wives do and directs two of his employees to help Mrs. Blitzer complete her online courses by logging into her online education account and helping her complete her homework and a test during work hours.
Okay, so if all of the other flags have failed, certainly this raises one for you. So this is what I want to sort of just point out here. So when she went to take the assessment test to get into the program at a different community college that she had already completed so much of at a different community college, like she didn't score high enough to not have to retake the test. I mean, to not have to retake the courses, right? So they basically were saying, like, you didn't learn enough, you've got to retake this stuff, right?
Yeah.
Okay. And so she didn't want to do that. The assessment tests are there for a reason, but whatever. Then when she did have to retake some of the courses, apparently either the attorneys or the assistants that work in the district attorney's office were getting online and doing her homework and taking the test for her.
Well, I mean, that's the best way to learn things is to have your husband's employees do it.
It is. So it's a lot. So I think, well, this is going to be a nurse, right? Like
one of the things that stands out to me here is, so first of all, we're talking about a district attorney's office this is happening in. Now, if this was like the corporate offices of like a gas station or a fast food restaurant, and like this is the place where all the franchises call in, and like the guy who owns the fast food company is like, employing his wife, that's one thing. But this is a district attorney's office where they've already sort of gotten their toe in the water with this bizarre wife swapping scheme. But now he's directing his employees, two of them, not one, two employees are helping his wife complete nursing classes.
And like, this is wrong. They're literally on, I don't know exactly how it's broken down, but whatever county or whatever, the district that they are the district attorney of is paying
for all this to happen,
to sit there and take the test for the wife.
Yeah. So
that's not a good use of funds.
Yeah, they're doing that instead of prosecuting murder cases.
And and the district attorney is instructing his office to do this. So this is the guy who's responsible for prosecuting crime in this district.
Correct. So in April of 2016, after the Shockley infanticide case file was taken by Mr. Bradshaw, Mrs. Blitzer enrolls full-time in a nursing program at a university. I'm not going to do this whole thing. I'm not going to like say who they are because I don't know anything about the university.
But it was like a physical place instead of online.
Yeah, it's a physical place. She's still employed by the state, and she's taking courses there 4 days a week. And the place that they describe is not close. It's like 2 hours away from where all this is happening. She's not working during this time, but she continues to enter her hours into Beacon, just like she's working her regular hours. So the time records introduced in this case, they show that she continues to do this until she leaves her position. Like her hours in Beacon are like clockwork. And you get a warning with Beacon, by the way. You get a warning that like this information that you're entering into a state system needs to be true and accurate, and there are repercussions if it's not. Mr. Blitzer testifies that during April 2016, he and Mr. Bradshaw traveled together to a statewide meeting of the Conference of District Attorneys in Ocracoke, North Carolina. So this is all the district attorneys in North Carolina.
I wonder how many more wives started working for their husbands' friends after that.
I wonder if there was like a course in like how to get your wife a nursing degree using available resources. During the drive to this meeting, Blitzer tells Bradshaw his wife had no work because he took the Shockley case file and no one is calling her back as to what to do. This is their testimony at trial. Blitzer testified that Bradshaw's response was to just have her concentrate on school and he'd get back to her. Blitzer testifies that his wife never received any further work from Bradshaw after this conversation. He testified to the best of his knowledge, his wife was still inputting hours as if she were working, like all government employees. He testified that he did not bring the issue up again with Mr. Bradshaw until October of 2016, because why not let the paychecks roll in for a while? Blitzer testified he and his wife were experiencing financial difficulties that were not resolved during this time and that they still needed Mrs. Blitzer's paycheck. Mrs. Blitzer testified she continued to submit hours without working because she needed a job and we had bills to pay. Mr. Blitzer acknowledged their financial difficulties contributed to his decision not to say anything about this non-work issue to Bradshaw. So we're down a rabbit hole now. In April 2016, the assistant district attorney who originally reported a problem with Mrs. Blitzer's hours to the SBI in 2015 again reported the case to the SBI that Mrs. Blitzer was attending school during work hours. The SBI opened a new investigation led by SBI agent David Whitley. Agent Whitley interviewed two 17A assistant district attorneys about Blitzer's work hours and school hours. Another SBI agent surveilled Mrs. Blitzer while she attended classes at the university during the hours she was submitting into Beacon. Blitzer learned about the new SBI investigation in June of 2016. So it's like barely even been 7 months since the other one came and went. He consults an attorney, but he doesn't tell his wife, and he doesn't tell Mr. Bradshaw, the other district attorney, about the investigation. Agent Whitley contacts Mr. Bradshaw, and they end up having a phone conversation during which Agent Whitley tells Mr. Bradshaw about the complaint regarding Mrs. Blitzer's payment for hours not worked. So they arrange a time for Agent Whitley to interview Mr. Bradshaw on September the 6th, 2016. Mr. Bradshaw calls Mr. Stoltz into his office on the 15th of August, 2016, and tells him the SBI is investigating Mrs. Blitzer's hours. Mr. Stoltz mistakenly believed he was no longer required to approve Mrs. Blitzer's hours, the submissions on Beacon. He hadn't done it since March of 2016, so he told Mr. Bradshaw that he could approve the hours that Mrs. Blitzer had submitted since the last approval, but before doing so, he asked Mr. Bradshaw if Mrs. Blitzer was still doing the shared employee program. Mr. Bradshaw tells him that she is, and Stoltz logs into Beacon and approves those hours. So on September the 6th, 2016, Agent Whitley comes and interviews Mr. Bradshaw in his office, and he told him the SBI is investigating whether Mrs. Blitzer was working the hours that she claimed. Agent Whitley testified in court that Mr. Bradshaw told him that Mrs. Blitzer worked on conflict cases with Mr. Stoltz, did special projects assigned by Mr. Bradshaw, and helped with District 17A matters under a shared employee program arranged between the two districts and modeled after a federal shared employee program between state prosecutors and federal U.S. attorneys' offices. Agent Whitley also testified that Mr. Bratcher said Mrs. Blitzer worked under that program as an employee of 17A while working in 9A. So do you think that that was really happening, or they were just making that up?
I think that is the best narrative they can weave out of what has been going on.
So during the interview, Mr. Bratcher identified for Agent Whitley employees who worked or had contact with Mrs. Blitzer, and Agent Whitley asked for additional information about any special projects that Bratcher had assigned to Mrs. Blitzer. But Bratcher told Agent Whitley he could not recall further details. He also said he would check with Mrs. Blitzer, but Agent Whitley told him not to contact her. When it comes to trial, Mrs. Blitzer testified that she had never been assigned a special project. Agent Whitley testified the overall impression that Bratcher gave him was that Mrs. Blitzer was working, but his impression was not tied to any particular statement made by Mr. Bratcher. He testified that if Bratcher provided information showing Mrs. Blitzer was working, the investigation would have been much shorter. So the investigation continues on into 2017. And Agent Whitley interviews Mr. Bratcher's employees over several weeks to determine the extent to which Mrs. Blitzer is working. So he believes early on, the special agent that is, he believes that she's working, but he's trying to figure out like what it is that she does. The Blitzers say that they contacted Mr. Bratcher in October of 2016, and Mrs. Blitzer said she wanted to resign following media scrutiny of her employment. The Blitzers both testify that Mr. Bratcher told Mrs. Blitzer she should not resign. They also testified that Mr. Bratcher told Mrs. Blitzer to keep entering hours into Beacon and that he would tell investigators that she had been working on special projects. So that's the next big thing that we get into here is now he can't come up with these special projects, but that's what he's going to tell these investigators. I honestly, like, you asked me something about these guys, specifically Bratcher, I think was the one who came up. Where did they get the confidence to do this? I think is how you phrased it.
Yeah.
It's they are definitely, there are some very big balls at play here to do this and think you're outsmarting an investigator because, you know, it is very difficult to discern when trained investigators are on your side or are not on your side. It is real easy to screw up and think the wrong thing. So Mrs. Blitzer testified she continued to submit time for hours that she never worked. Gail Peed, who was Bratcher's administrative assistant, testified that on October 24th, 2016, Bratcher directed her, so directs Gail, to call Mrs. Blitzer and fire her effective that day because Mrs. Blitzer would not speak with him. So she did so. Mrs. Peed calls and fires Mrs. Blitzer. She also testified that at Mrs. Bratcher's instructions, she responded to an email from AOC regarding Mrs. Blitzer's time record. She testified that Mrs. Blitzer never responded to a request to verify her hours and that according to Mr. Bratcher's direction, the reply email informed the AOC that Mr. Bratcher and she couldn't certify Mrs. Blitzer's time because Mrs. Blitzer was under investigation. So that's the point where I started to realize that, like, this guy thinks they're going after her, and he doesn't realize that they're just investigating to see what's happening. Would you say that's fair? Or?
I don't know how to say this nicely. I feel like any district attorney should have recognized what was happening.
Oh, absolutely, they should have.
But I don't think that he did.
He did not. I would say just the level of education, time, and experience you have to get into the position he had gotten himself into. Anything he does at this point, he could make mistakes, he could make stupid decisions, but like he's just having trouble with his failure to recognize what is happening around him. And I think that plays into like the whole situation for Bratcher. It plays into him thinking he's smarter than he is.
Or being completely oblivious.
Either one would work for me, actually, I think.
I don't know which one it is.
I can't tell either. I mean, it's wrong either way, but he's making concerted efforts to sort of cover things up, but then he does things that are so stupid. Firing her. I mean, that just makes it all look so much more suspicious.
Right, but she wouldn't talk to him, and yet, like, okay, so she wouldn't talk to him, so he fired her. But earlier, Agent Whitley had told Mr. Bradshaw, who was Miss Blitzer's boss, not to contact her.
Correct.
There's months between the point where there's a problem and then she's finally fired. How can you be working if your boss doesn't contact you?
And is told not to contact you.
By
I
the
mean,
FBI, no less.
yeah, I am totally curious. Like, I don't see the physical documents anywhere. I know that they were passed around at one point. I'm curious, like, how long she just kept entering hours in the beacon. Like, it doesn't spell out exactly like the last time that she entered hours in there, what, like when that was, but that's got to be late in the game at this point that like they're able to have this conversation where she's being fired after you told her
Well,
not to quit.
Miss Miss P called and fired her though.
Right.
And you have to keep in mind, so he fired her because she wouldn't talk to him. That's probably like the only boss move he pulled the entire time she worked for him.
Yeah.
But I have a feeling that they had obtained an attorney, and the attorney told her not to talk to him anymore.
I believe that's what's happened because so here's what happens with Mr. Blitzer. He doesn't give a statement to Agent Whitley until May of 2017. So we're basically almost a year into this when he gives a statement. Now, for the outcome for Mr. Blitzer, it affects the rest of what I'm going to read. So I'm going to go ahead and tell you. Blitzer, he pleads guilty to the misdemeanor failure to discharge his duties. He repays the state $48,000. That is the money for those lost hours that Mrs. Blitzer had wrongfully accrued. He consents to a suspension of his law license, and he agrees to cooperate in both civil and criminal cases against Mr. Bradshaw. In exchange, the state agrees to decline any further prosecution of either of the Blitzers for any crimes specifically related to Mrs. Blitzer's employment. So that's never a good sign, by the way, when somebody gets that kind of immunity, because it doesn't happen like it does in TV and the movies. It's a limited immunity. It's not blanket immunity, but the gist is, as long as they haven't done anything major beyond the scope of what they've told and they're truthful going forward, they're not going to see anything other than this $48,000 recoup of the money, this misdemeanor, and whatever is happening related to the suspension of his law license, which I haven't looked up yet, but I'm guessing it's probably not permanent. October 24, 2017, a grand jury returns a bill of indictment against Mr. Bradshaw with 7 counts, charging him with conspiracy to obtain property by false pretenses, failure to discharge his duties, and 2 counts of obtaining property by false pretenses, and 3 counts of obstruction of justice. The obstructing justice charges are lies, basically. The rest of it is related to the wife swapping employment setup. He's tried on all these charges on the 29th of May, 2018 in Superior Court down in Wake County, North Carolina, which is the Raleigh area. So during the state's case, the trial court excludes testimony from Mrs. Peed as hearsay. This ruling is the reason we have this document. Mr. Bradshaw challenges Mrs. Peed's testimony being excluded as hearsay on appeal. Does that make sense to you?
Yes.
Okay, so after the state rested their case, Bradshaw moved to dismiss each count based on insufficiency of evidence. The trial court denies the motion to dismiss. Basically, this is sort of a blanket motion that you can throw in between.
That everybody always throws in.
Yeah. Everybody wants you to, like, the motion to
Just in case
dismiss.
the judge sees something that they could possibly throw it out. This is before any defense is put on. This is after the state closes the prosecution side.
Yeah, so they rest, and the defense moves for a dismissal. Trial court denies it. And Mr. Bradshaw took a very interesting approach to this, which you see it from time to time. It's more common than
I've
people
talked
think.
about it.
Yeah. He declines to put on a defense.
Right. Which
So,
I like. This isn't like a murder trial or anything, but it's a good example.
yeah, this is a great example. Essentially, he declines to put on any kind of defense or present any evidence of his
And so
own.
that would be the motivation behind that. I believe he represented himself. Did he not? He seems like the kind of guy that might.
He has an appellate defender here, but
I believe during the trial he
I
represented himself. And so by not putting on a defense, by choosing not to present evidence after the state had rested the prosecution, his theory was, whether he was doing it or if he had an attorney doing it, his theory was that the elements of the laws that he had been indicted on had not been met. And therefore, the elements that would say that he had committed the crime, having not been presented by the state, they would fall short of the jury being able to convict him of the crimes. And he therefore had no reason to give any information at all. I feel like that's a huge leap. I mean, just the fact that I'm not even sure most juries would even understand what's happening there. In fact, I cringe to think about it, but sometimes I worry that when you don't put on a defense, that if it's not properly explained and the instructions aren't really good, or if like somebody's taking a nap and not paying attention, like they think that you just accepted everything the state just said is true.
yeah, pretty much. That's ultimately that is one of my concerns, and I have concerns the other way sometimes. Like, do they think the state is so crazy that this person's not even going to try and like
I don't know.
combat them?
I don't know. I feel like when I do think it's interesting that he didn't put on a defense.
Yeah. So what happens here is the evidence is all closed out. Bradshaw renews his motion to dismiss. Again, it's denied. But he's got a lot of stuff on the record, which is really why you object in motion throughout the trial. In a case like this, is you're basically preserving the record for appeal. And honestly, with the way that this case was going, I don't know that you could mount a good defense other than like an ignorance defense, and that like would not go well. What's okay? So here's what's crazy about this: you have a district attorney, and I believe this would have been under Lauren Freeman, but I'd have to like look that up. She would have been at the time, I believe she would have been the Wake County District Attorney. So I think she's trying the case on behalf of the state at the trial level. Not 100% sure, but so you have a district attorney prosecuting a district attorney on the word of district attorneys, and you've got like a room full of witnesses that are all legal assistants, district attorneys, assistant district attorneys. It's like this carnival of errors happening and unfolding. And that's like the reason this case is so fascinating to me. As expected, on the 18th of June, 2018, the jury finds Bradshaw not guilty of conspiracy to commit the offense of obtaining property by false pretenses and one of the felony counts of obstructing justice. They find him guilty of failing to discharge his duties as an elected official. They find him guilty of felony obstruction of justice, which is because he lied to Agent Whitley. It is a crime to lie to a state agent in North Carolina. He gets misdemeanor obstruction of justice based on the provision of providing false information to Mr. Stoltz. So this is when basically he told Stoltz to sign off on the time cards and that she was a part of the shared employee program. It becomes obstruction of justice because they're both district attorneys. Stoltz is an assistant district attorney. Bradshaw's a district attorney. So two government employees talking to each other, it becomes obstruction of justice if one of them lies to the other. Isn't that fascinating?
It's something.
All of this happens, and what we're looking at is an appellate document. The defendant in here, Bradshaw, he has raised 4 issues on the appeal from everything I just said. The first one is he says the state failed to prove that he impeded, delayed, or obstructed the investigation by intentionally making false statements to Agent Whitley on the September 6, 2016 interview. Secondly, he says they erred in excluding Mrs. Pete's testimony about the defendant's statements. Thirdly, the trial court plainly erred in failing to instruct the jury on the specific false representations alleged in the indictment. His last issue on appeal is that the state failed to establish the defendant personally committed or acted in concert to commit the act of obtaining property by false pretenses. So when this goes before the North Carolina Court of Appeals, they have to break down each of those four things that Bradsher has raised. What they do is they look at his argument that the trial court erred in denying his motion to dismiss. And he has stated that they didn't give enough evidence that he had intentionally made false statements during the initial interview by Agent Whitley. And surprisingly, the North Carolina Court of Appeals agrees. And they state several cases in here basically saying, like, this is our holding. And I'm not going to go through like all of the parenthetical citations for this because it wouldn't make a lot of sense. But they do say that the North Carolina, they say our Supreme Court has long held that it is error, generally prejudicial, for a trial court to permit a jury to convict upon a theory not supported by the bill of the indictment. Basically, the defendant says that there was no evidence of this act alleged in the indictment. And the Court of Appeals agrees with him. He argued that the state failed to introduce anything saying that Mr. Bradsher made a specific false or fabricated statement, and instead that Agent Whitley testified the conversation merely left him with an overall impression that Mrs. Blitzer was actually working. An overall impression is not specific enough to be a charge, is what the Court of Appeals is saying. The state argues that Mr. Bradsher's statements to Agent Whitley that Mrs. Blitzer worked on conflict cases and that Mrs. Blitzer worked on special projects that he had assigned to her, and this is all in quotes, were false. But they didn't specify a particular period of time. So the statement that Mrs. Blitzer had worked on conflict cases was not false. The statement does omit the fact that essentially she had not been working on a conflict case for months. But it's misleading, not false. Do you see that distinction there?
I do, yeah.
Do you agree with it?
I respect the court's opinion on it.
Yeah, I respect their opinion on it. And I think had he not preserved that on the record, I do think maybe a little more would have been gotten away with there. The agent, I think, was being too general in that first interview. And I think Bradsher was also being too general for the court to really take up any kind of issue. So in the light most favorable to the state, that's how it would be looked at because they have the conviction here. They can't say that particular statement is false. I think it is misleading, and I agree with them saying that, but I don't know how I feel about the false part. I don't see it as a false statement. I see it as the investigator should have followed up with a more specific question.
I would agree with that, definitely. Because I do feel like a lot of this, this has been constructed into a narrative. So there's no way to know if, like, he could have genuinely believed that she was working on special projects or whatever, right? I mean, and so in the event that he believed that, even if she wasn't doing it, he's not making a false statement to the agent if he believed that she was working on special projects.
Well, the other side of this is, weirdly, it is not technically a crime to make more work for an investigator. In this instance, like I said, he wasn't asking specific enough questions. And he even, Agent Whitley even says this. He says that his investigative path was going to be to document any work that Mrs. Blitzer may have done. When he says that, he's leaving open the possibility that she didn't do work.
Well, right, but he's also that takes the investigation a whole different way, in my opinion.
Yeah.
So anyway, I feel like he would have needed some there would have had to have been some evidence presented that he knew she wasn't doing, the specifics of what he said, and that, let's say emails or whatever, right? You know, if he knew specifically it wasn't happening and he led the investigator to believe it was happening, that's a different story. But that's not how it was presented. It was presented that this conversation was had, this is what was said, and there was really no follow up. And it falls on the state to prove its case, right?
Yeah, and
It
this
doesn't fall on the defendant to, prove they didn't do it.
well, the state screws up here in their response to the appellate document here. The state presents an alternative argument where they, and this is their quote, obstruction occurs whenever a person acts intentionally to hinder justice. So the state argues obstruction occurs whenever a person acts intentionally to hinder justice. However, the Court of Appeals points out this is not a correct statement under the law. To support a conviction for the obstruction of justice, the state must establish substantial evidence for every element of the crime, including the act in question obstructed justice. So they're going to kick this felony obstruction of justice, but here's the reason why. Because the investigation continued. What Bradsher said did not one way or the other really influence Agent Whitley. And Agent Whitley had an investigative path that continues for a year.
Right, and he could have gotten the information a different way. I mean, yeah, I don't think there was obstruction there.
So I agree with you. There's not obstruction. So that ends up being decided in Bradsher's favor. So the second point that he was arguing was the exclusion of his employee's testimony. So the defendant next argues that the trial court erred in excluding Mrs. Pede's testimony about his statements to her as hearsay. At trial, Mrs. Bradsher sought to elicit testimony from Mrs. Pede, who is his administrative assistant, about an email sent to the Administrative Office of Courts based on Mrs. Bradsher's instruction not to certify Mrs. Blitzer's last set of hours, when Mrs. Blitzer did not respond to an inquiry about whether the hours were valid. The defendant contends that the email tended to show he did not know that Mrs. Blitzer was submitting false hours in her beacon entries. And then they outline an exchange. These are my favorites, by the way, when they put the exchange in here for us. So the following exchange occurred on cross-examination of Mrs. Pede by Mr. Bradsher. Mr. Bradsher, okay, do you recall in a form tendered by AOC the District 9A's positioning about approving Mrs. Blitzer's hours and Mrs. Blitzer's lack of response? Prosecutor, objection. The court sustained. Mrs. Bradsher, all right. After you received an email from AOC, what did you reply that you recall? Pede says that we had not received any response from Cindy Blitzer, and she was under investigation, so we couldn't. And then there's an objection by the prosecutor. At this point, the trial court excuses the jury, so they send them out, and they examine the testimony of Mrs. Pede. Mrs. Pede responds to the prosecutor's question about the source of the information in the email as follows. So this is Pede's response. After I talked with Mrs. Bradsher, I showed him the email that the AOC sent. Initially, the first time it was sent, Mr. Bradsher told me to email Mrs. Blitzer and see if we could get her to certify those hours. Sometime later, the Administrative Office of the Court sent the email back again asking for a response, and I took that to Mr. Bradsher and said, Cindy Blitzer never responded, and Mr. Bradsher told me to tell AOC that we couldn't certify the time because Mrs. Blitzer was under investigation. So I answered the email in that way. So Mrs. Pede agreed that it was not her decision to send this email of her own volition. Her decision as to what she was going to put in the email, it was based upon the discretion of Mr. Bradsher. So Bradsher at this point argued that Mrs. Pede's testimony about the content of the email is permissible alternatively because it falls under the business record exception. Because the state opens the door to this because the prosecutor asked Mrs. Pede about other statements Mrs. Bradsher made to her. He also said the statement is not hearsay. The trial court ends up holding that the message to the AOC is hearsay and they don't admit it. I mean, I guess, should we explain what hearsay is in these terms, do you think?
Sure.
Okay. Hearsay is a statement made by a declarant while testifying at the trial or hearing, offered in evidence to prove the truth of the matter asserted.
Right.
Typically,
It means that somebody heard somebody say something.
yeah, literally, it's something they heard said.
Right. It's not something that they can know for certain. Like, for example, for this to not be hearsay, there would have had to been more information from Miss Peed that she was aware of. She was making the statement on her own information, and that she was aware of an ongoing investigation, like from firsthand knowledge, not because her boss told her.
Right. So the argument is that these are directions. He's arguing that her testimony about his statements to her don't qualify as hearsay because they are directions. And the defendants, he cites a case called State versus Mitchell from 1999, in which the appellate court held that directions, commands, and suggestions are not hearsay because they are simply offered to prove that the directive was made, not to prove the truth of any matter asserted therein. It's not about whether the information is true or not. It's simply that the information got there in this particular way. And he's saying because it got there by him saying it to her, it is not hearsay. Does that make sense?
It makes sense to me, but nobody was buying it. Well, actually, that's not true. They
That's
didn't
not-
rule on it. They said that he didn't preserve the argument for appeal.
Yeah, so they note that the state contends that the defendant's argument that Mrs. Peed's testimony is not hearsay because it is a direction is not preserved for the argument. To preserve an argument regarding the admissibility of evidence, a party must have presented to the trial court either a request, an objection, or a motion stating the specific grounds for the ruling that the party desired the court to make if the specific grounds are not apparent from the context. So here, the state says that the defendant never argued this before the trial court, that the statement was not hearsay because it was a direction. The state acknowledges that the defendant asserted that the statement was not hearsay, but he didn't say why. So the state argues he did not explain the statement further at trial and later conceded it was hearsay because he wanted to admit the statement to show the truth of what happened. So they sort of spin it on him. The court takes a look at it, and the gist of it is, like, they read this long kind of transcript of him talking about it. The gist of it is he did not preserve it. So they can't do anything with it because he didn't preserve it for their review by stating a specific objection.
Right, because the trial court has to actually make a decision before an appeals court can overturn it.
Yeah, so the trial court essentially is ruled to not have made a decision on whether or not the statements that Mrs. P was making were commands. They simply ruled them as hearsay because they were from one about another, essentially.
Correct.
So then we get into the jury instructions. That's the third argument that he made. He argued that the trial court plainly erred by failing to instruct the jury on specific false representations alleged in the indictment. We note that the defendant has specifically and distinctly contended that the error at issue was plain error, as is required for this court to review instructional or evidentiary issues not otherwise preserved on appeal. So while he didn't get this in front of the trial court, he figured out a way to get this around by calling it a plain error. For an error to constitute a plain error in North Carolina, a defendant must demonstrate that a fundamental error occurred at trial. To show that an error was fundamental, a defendant must establish some form of prejudice that after examination of the entire record, the error had a probable impact on the jury's findings that the defendant was guilty. Moreover, because plain error is to be applied cautiously and only in the exceptional case, the error will often be one that seriously affects the fairness, integrity, or public reputation of judicial proceedings. They go on to give several citations for examples of plain error. So in this present case that they're dealing with, Bratcher says that the trial court erred in failing to instruct the jury on what particular false representations alleged in the indictments are. The state alleged 2 counts of obtaining property by false pretenses. So the first count, the allegation is that Bradshaw and co-conspirators submitted fraudulent entries of hours worked for Cindy Blitzer. So this is the beacon system stuff. On the other count, the state had to prove that Cindy Blitzer submitted fraudulent entries of hours worked for herself to the AOC. Does that make sense the way that I just said that, Meg?
It does.
Okay.
But yeah,
But
it does.
go ahead if you have something to say about it. It's weird what they do here.
Yeah, I mean it does, but I forgot we're just talking about this is the jury instruction, right?
Yeah, this is the jury instruction as it relates to the false representation from the indictments. It's a basic. It's a very semantic thing they're doing here.
Right, and ultimately the Court of Appeals found no error with it.
Right. So the Court of Appeals basically looks at it and they said there's nothing that we could do here. They did not err nor plainly err in failing to give any instruction about the misrepresentations alleged in the indictment. So that's a weird statement. They're saying that the judge didn't screw up by not pointing out that the prosecution was essentially asking them to make a conviction out of something that they didn't really allege. So it's a prosecutorial problem, but there's nothing that can be done here because it ultimately doesn't matter.
Well, right, because isn't that the acting in concert part of the charge that they're about to vacate?
Right. So that's where we get to the last argument, which is the defendant argues the trial court erred in denying his motion to dismiss the charge of obtaining property by false pretenses based on the theory of acting in concert. As an initial matter, the court notes that the trial court arrested the verdict on this charge after the jury returned verdicts for 2 counts of obtaining property by false pretenses. For an appeal to be properly entered before the court, the appeal must rise from a final judgment. So we have a problem right off the bat in that an arrested judgment
isn't final.
It's not final. It's not even considered to be adjudicated. So in certain cases, an arrest of judgment does have the effect of vacating the verdict. But in other situations, an arrest of judgment serves only to withhold judgments on a valid verdict, which would remain intact. So they do poke at this a little bit. And they sort of go through some of the holding cases in North Carolina. And ultimately, what they do here is they hold that there was insufficient evidence to support a conviction for obtaining the property by false pretenses based on the theory of acting in concert because of that other statement, which is that Cindy Blitzer would have had to have been the one inputting it, and he would have had to have been there with her sort of directing it or overseeing it in some way. And ultimately, they don't find that's what happened. Is that how you read this?
That's right. And that's why the jury instruction doesn't matter.
Right. So so 4 basically negates the earlier jury instruction argument. And they get really detailed in this. They basically say that at the end, there's insufficient evidence to show that defendant Bradsher was constructively present when Mrs. Blitzer inputted the fraudulent hours. So they hold that the trial court erred in denying the defendant's motion to dismiss the charge of obtaining property by false pretenses on the theory of acting in concert for something the Blitzers had already pled guilty to, and that gets kicked out. So what ends up happening here, in conclusion, class, they held that the trial court erred in denying the defendant's motion to dismiss the felony obstruction of justice. They hold that the defendant didn't preserve the argument from Ms. Pede's testimony. They further hold that the trial court did not err with the jury instructions, but they kick the defendant. They say the trial court erred in denying the defendant's motion to kick the charge of obtaining property by false pretenses on the theory of acting in concert. So they're vacating the offense of felony obstruction of justice. They vacate the obtaining property by false pretenses, and they remand this case back to the trial court to re-sentence the defendant based on the charges of misdemeanor obstruction of justice and failure to discharge duties because they had been consolidated with that felony obstruction of justice. Anyways, we got all the way through it. Yeah,
right?
it's gone.
Now
So
I'm confused. Like, when did the arrested judgment become finalized so they could vacate it?
I am telling you now that like they're sending it back to the trial court and basically saying, "Will you please sort this out?"
Okay, well, I feel like this is a super complicated case, and for a lot of reasons, but one of the biggest things here is basically, you know, there were two district attorneys and their wives, and then some other people involved. And at the very end of it, we've got one of the district attorneys taking a plea and paying restitution, right?
Yeah.
And we've got another district attorney who has faced 7 counts that were that a grand jury indicted him on. That
Yes.
in turn result in he ends up with just 2 charges by the time the Court of Appeals is done with it, right? He basically or actually that may not be true because he could have had something else that wasn't consolidated with the felonies. He no longer has a felony though. Okay, so first of all, what do you think about their choice of defendant here?
What do you mean their choice of defendant with them going after this guy?
Yeah.
I wondered if there wasn't something more to him. Like I was wondering if they were going to charge him with more things that we don't see because this is all they could get indictments on. Because Blitzer, in August of 2021, Blitzer, whose wife was definitely benefiting from this, he ends up getting his law license back. Do you
When
know
did
this?
that happen?
August of 2021, he's met all the requirements to satisfy.
Well, was Bradshaw disbarred?
Okay, so
It wasn't part of his punishment.
So there's more to Bradshaw's case. So he's no longer the district attorney of Person County.
Probably a good thing.
I don't know the answer to that question, but I'm going to look it up.
Well, I feel like so I say it's probably a good thing he's not the district attorney anymore. Not because I'm saying anything about his character, but at the very best situation here, this guy didn't know what was going on, right, in his office. Now, it seems pretty clear that he was willing to give his friend, who happened to be a district attorney in another district, his friend's wife, a job. And it's an inkling towards the fact that he realized that like her mind wasn't completely on work, but she was logging work hours, right?
Yeah.
And so you have to sort of keep in mind this wasn't the only thing this guy had going on, right? I mean, he had tons of stuff going on. It doesn't give any information about like how many people actually worked for him. It doesn't give like any information to sort of get you more into the environment that it was actually happening in, like how many cases were going on, like that kind of thing, where like what attention would this matter have really gotten from him based on his workload and what was happening, right? Because it could be that he literally didn't think about it,
right,
you know, except like this handful of times that it's mentioned. Now, it seems to me like there was a deceitful quality to the actions. Mr. Blitzer certainly knew because, I mean, I figure that what happened was he needed to save his wife because if you'll recall, Mr. Bradshaw's wife was out of this long ago.
Yeah.
And so I have a feeling that the reason he took a plea deal was because essentially if he didn't take a plea deal, they wouldn't have had a case against anybody. And by taking the plea deal, he got his wife out of trouble because, you know, there's no way to know like how much has really occurred and what they might go after. And essentially they went with what they had, you know, whoever talks first gets a deal, right?
Yeah.
And so I don't know that it was necessarily fair in this case.
Thank you for joining us. We are sponsored by LabbratiCreations.com. You can check them out at LabbratiCreations.com, and you can still use the code CRIMEXS for a fun pop pet portrait of your own pet. You can also reach us on Twitter, Instagram at TrueCrimeXS, or you can give us a call if you know anything about any of the cases that we're talking about at 252-365-5593. You can also reach us at Gmail at truecrimexs@gmail.com, and you can check out our website at www.truecrimexs.com. We'll see you next time.
This is True Crime XS.
I did find his disbarment, and
Yeah.
it is an interesting document in and of itself. It's basically he ends up in judges' chambers, and they tell him it's inappropriate for him to practice law while there's an appeal going on in his case. He's contested the charges.
He was
and
practicing law.
yeah. So he ends up surrendering his license to practice law. He's considered at this point disbarred, but that's not even why he's here. That's not what he's in. This is not even why I brought this case up today. Back in 2015, a lady named Betty Yarborough Jackson was living over in Roxborough. She won the lottery twice in 3 days. Okay. She got a bunch of money. And one of the prizes was like 150 grand. I don't know what the other one was, but this is not a small amount of money, but it's not a huge amount of money. So she wins the lottery twice, and I don't know what is happening in this, but this is 2015 that she wins it. The reason this guy is here is because I got another news brief about him on July 19, 2022. I got a press release saying that a grand jury on Monday handed up indictments against Wallace Bradshaw for accepting a bribe and obstruction of justice related to a 2015 case where he was district attorney. Search warrants from the FBI obtained by WRAL show that Betty Yarborough Jackson, the woman who won 2 lottery prizes in a day, paid Bradshaw with some of her lottery winnings to get drug charges against her son dropped. So she got arrested on Monday on charges of offering a bribe and obstruction of justice. Bradshaw, who has not yet been arrested in this case, was convicted in 2018. He served months in prison in the wife-swapping no-show job scheme before some of those charges were kicked, but he is considered to be disbarred. What do you think about that nonsense? I think they were trying to get him on something bigger.
I'm not sure that there is going to be anything.
It's just going to be dirty little
huge.
nonsense, isn't it?
Well, that's sort of what I'm getting. I don't know that he's completely aware. I like to think that like there's no way this guy could be completely aware that like he shouldn't be doing that, because why would you do that? Why
I have
would you
no
risk
idea.
your entire, I mean, because he's thrown everything in the garbage basically.
Yeah, he's had an active law license since I think either 1989 or 1990. It's a long time now.
And it was for a friend's wife. That it doesn't make sense. It seems like they were going to have this arrangement. And, I stand by the fact that there was a hell of a job done to get this into a narrative that was cohesive enough to understand it, right? The parallel roads that occur, though, the narrative with everything that happened is, there is more to it, right?
Oh, it's absolute. There's got to be some bullshit elements to this. I just can't figure out what exactly they would be.
I could take some guesses, but it really doesn't matter, because ultimately either he was up to no good or he wasn't paying attention. So either way, he's wasting resources by paying people who aren't working, and that's just not a good thing. Um, and then, now that he's been, you said it was the 19th, so that was like yesterday,
This
right?
is the new indictment. Yeah, he just got indicted.
There's no telling what else is going to come out of that. I feel like if he really felt like he was smarter than everybody, there may be a lot of these little things happening. Um, and he may be paying for it, which, I don't know, how I feel about financial crimes. And I do think that I
I don't
just
know.
wish
Like, this isn't, to me, this is not about the financial crime aspect. I mean, it is in a
the
way, but
only thing that caught the attention was the money, because the money is paid for by the state. That's why, I mean, yeah, it's a financial crime. He was making a way for somebody to fraudulently get funds from the state.
I just think it's ironic
That's
that you have your wife working in the district attorney's office next door on charges that you had a conflict of interest with. I mean, that's weird. But also, my problem with all of this is nepotism in the district attorney's office is a terrible idea. And if you need to look in South Carolina to see why it's such a terrible idea, you can see why lawyers and people who've been prosecutors for years and years and years make a giant mess with what they leave behind. That's the Murdaugh craziness.
He wasn't a prosecutor, was he?
His family,
Just in private practice, right?
so the way that works is
I think they call them solicitors there.
his family is the family that started, so he's the heir to the solicitor's office in that area. The Alex Murdaugh is.
Except, that really shouldn't be a thing.
Well, he's not really, he's just a mess. But what I'm saying is they barely have district attorneys there. They have solicitors. His family created what solicitor's office they have, like his grandfather, his father, his grandfather, and his great grandfather were Hampton County's prosecutors for 87 years.
Right. And he has been in private practice.
He was never a county prosecutor, but he worked off of their name.
He carried the clout,
right,
that the family had from being the law in their parts, which is basically how that's how they were portrayed, and more importantly, that's how the community perceived them.
Yeah.
And so while he wasn't necessarily a district attorney, his family, they were heavily involved in the prosecution of crimes there, and suddenly the walls all fell in on him.
Yeah, that's a whole different thing.
Yeah, you saw where he was charged with
their murders.
Yeah.
I was trying to get as much information as I could get on the Kristen Smart case, and there's a name in common there or something, because he keeps popping up in my news feed. But her case is ongoing too. That's a lot of true crime news we just crammed into 2 sentences.
Things and this place taking flight.